court this morning is Rhonda Wheatley versus Howard Hanna Real Estate Services. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, you want to let me know. I'm keeping the clock this morning. The court has read the briefs and we're ready to proceed with you are. Do we have everyone here for this case this morning?
I believe so. Good morning, my name is Jonathan Rosenbaum. It's my honor to appear before you on behalf of the appellant, Rhonda Wheatley. I would like to reserve 5 minutes for rebuttal. As I'm sure the court is aware, my client owned a home which she put up for sale with Howard Hanna and Linda Schubeck. I think most of the facts in this case, if not all, are uncontradicted. They signed an agreement. The agreement was found by the trial court not to shift the responsibility for security to the owners of the home. The real estate agent admitted that she did not know it was going to be an open house open to the public. My clients were told that it was only a broker's open house. They operated under that assumption. They followed Ms. Schubeck's, the realtor's, advice to the letter, saying to hide things. This was conceded. Eventually, it was discovered by Ms. Schubeck that the open house was publicly advertised, that members of the public got in. In fact, the realtor called my client because of some troubles at other open houses and asked if anything was missing, whereupon they discovered they were missing $56,000 worth of appraised jewelry. It was uncontested at trial that there was a duty to exist. A duty existed between the real estate agents and my client. I feel that that was a proper conclusion. The case law is clear that where there's a special relationship between the parties where harm may reasonably be expected, that a duty of care exists. Ms. Schubeck conceded that she was in sole control of this home, that she asked my clients to leave. They accepted her advice. That again, I say that they complied with her instructions to hide the articles indicating and proving that Ms. Schubeck knew that there was a danger that she had to protect for, and she admitted that neither she nor anyone else took any efforts whatsoever to look out for my client's interest or protect their property. I submit under these circumstances that summary judgment should have been granted for my client in the whole amount of $56,000, but if not in that amount, at least there should have been summary granted on the issue of negligence, and the case should have gone to the jury only on the amount of damages weren't in dispute, I guess only on approximate comparative negligence. But that didn't happen. The trial court, as if you read its entry, I think intertwined the fact that, or misinterpreted the fact that my clients did not lock the safe that was hidden in their closet behind clothing and a door, and this should have been considered only for contributory negligence. The trial court, in its entry denying summary judgment, said that this was an issue of fact that existed. I respectfully say that it was an issue of fact, if any, that only existed on the issue of comparative negligence, and had the case gone to the jury only on the issue of comparative negligence, I think there would have been a very different outcome. But in any event, it was error not to do that. I respectfully submit it was error not to grant summary judgment. The evidence at trial did not differ greatly from the evidence that was adduced for summary judgment, except I think it was even stronger in some ways because Ms. Schubeck again conceded that she made no efforts whatsoever to look out for my client's property, and that no one did. The law is clear on when a court should grant a judgment notwithstanding a verdict. I think practical matter, there's no difference in summary judgment. It's just that it's considering all the evidence at trial. Linda Schubeck conceded that had she gone with this stranger that came to the house, and followed him around, and the thefts could not occur. I submit respectfully that as a result of that, the issue of whether the safe was locked or not is a nullity and could not have even been considered as comparative negligence, much less mistakenly on the issue of proximate cause. It was uncontested at trial that had she done something to protect these people, that she admitted it was her duty to follow this guy around the house, but she didn't, and she admitted that had she done so, he would not have been able to take the jewelry.
So, counsel?
Yes.
There seems to be a disagreement as to what duty was admitted. You just indicated that the realtor admitted it was their duty to follow this gentleman around the house.
She admitted in her testimony, I believe it was on the page, that she should have done that as a real estate agent.
What if it was an open house, what if there were 3 or 4 parties that all came at the same time? How would she be able to have done that?
Well, if she's going to be in charge of the house and she wants to tell my client it's a broker's only open house and she accepts the premises on those terms, and then it would be her responsibility to take whatever steps are necessary to either have more people there or take them through as a group or make them go through one at a time with her. But my clients were not in a position to even evaluate the risk to their property as a result of the misrepresentations Ms. Schubeck made. She never informed them that it wasn't going to be a broker's only open house. She never informed them that no one would be looking out for their interests. She never informed them that she was going to sit about as far away from the door as you could sit with no view of the door and have no control over anything while she ate her lunch.
Well, but one of the issues that the appellee brings up is the fact that the facts demonstrate that your client may not have been informed of all that, but yet were aware of it due to the fact that they saw non-brokers going in and out of the house and were present during the
My client would not know who a non-broker was or a broker.
I thought the neighbor went in.
Well, I don't think my client, well, I don't remember that, to be honest with you, but even if that's correct, it doesn't mean that the real estate agent should not have taken that person and taken her around and made the same efforts. I mean, this is an unusual case, and for some reason my client seemed to be taken to task for one thing for having a safe in their house. The law should not turn on whether or not they had a safe and took the extra precaution but forgot to lock it. I think that the way this case turned out, that if my clients didn't buy that safe, they'd have been better off not having it. The other thing is, I don't think you can fairly shift the burdens to my client. My client wasn't even supposed to be there. She returned for something she forgot, and they would have her be penalized because she may have recognized her neighbor go into the house. The real estate agent has, I believe, under the law, has the duty to protect those premises, to make reasonable efforts to do so under these circumstances, whether it would be the neighbor or a broker that wasn't known to Ms. Schubeck. Because my client went back there by coincidence to get, I think, some baby formula or something, I don't think should shift the burden to her for the protection of the house for the brief time that she is there. And finally, I would argue that obviously if the court should have granted a judgment or summary judgment and a verdict, judgment notwithstanding the verdict, I think that my client certainly should prevail on a manifest way to the evidence argument when all issues of credibility are weighed. But I guess what I want to say in closing, most importantly, is the facts in this case are uncontradicted. The real estate agent, Howard Hanna, did nothing to advise my clients of the danger, did nothing to protect them for anything. And I think they have a duty, and it was conceded that if Ms. Schubeck did what she was supposed to do, that wouldn't have occurred. Therefore, I think there should have been judgment notwithstanding the verdict. I think the verdict is against the manifest way to the evidence, and I think based upon the issues before the court, that it got confused when it should have granted my client summary judgment with the issue of comparative negligence for not locking. Thank you.
Good morning, Your Honors. My name is Tracy McGurk. May it please the court.
Counsel,
I'm sorry.
could you use this phone, please?
Oh, I'm sorry.
That's okay.
I'm sorry. This one.
That's okay.
May it please the court. My name is Tracy McGurk. I'm here on behalf of the police and defendants, Linda Schubeck and Howard Hanna. Obviously, as far as, I'll just kind of go through the assignments of error. Obviously, the first assignment of error, we feel the trial court did not err in granting or denying plaintiff's motion for summary judgment. Clearly, there were lots of issues of fact in this case that precluded a summary judgment. First of which was the issue whether or not Linda Schubeck and Howard Hanna are responsible for the acts of their criminal acts of third parties.
That's an issue of fact, though, right?
I'm sorry.
That's not an issue of fact.
Well, I guess legally it was for the court to determine, but they argued that whether or not there was a special relationship, you'd have to determine if there was a special relationship between Linda Schubeck and this individual. We would argue there's an issue of fact that the jury determined whether or not the special relationship existed, which we argue they did
Why
not.
wouldn't that be just a matter of law too?
Well, I
Between
mean,
a real estate agent and their client?
well, I meant the special relationship between the individual that came in and that committed
Oh,
the crime, the thief, the alleged thief.
We don't.
And I will say that we don't know who did it. I didn't keep up with the criminal aspect of it, but at the time of the trial, it was never determined.
Do we know if it was that man?
We don't. It was always assumed it was, but arguably nobody knows.
It could have been a broker.
Yes. For the purposes of what the jury knew, yes. Nobody, at trial, there was never, ever any evidence, there was never any evidence who committed the act, whether it was this alleged man that we think, or that was thought to be, or whether it was a broker. Also, we felt there was issues of access to proximate cause, whether or not it was foreseen that we could anticipate that somebody would come into the open house. We also thought there was an issue of fact as to whether or not Linda Schubeck explained appropriately about the broker's open. Also, we thought there was an issue of fact of comparative negligence. We also, in the summary judgment, argued the listing agreement contained language that provided that the plaintiff would be responsible for the security of her own home. So arguably, we felt that there were a lot of issues of fact that precluded the summary judgment. As far as the judgment was notwithstanding the verdict, we thought, again, the court did not err in denying that motion. The standard is looking at the sufficiency of the evidence. The only thing I will point out is that the court never found that the listing agreement did not shift responsibility. They kept it out because they felt that the listing agreement would confuse the jury as to, they didn't think the language was clear enough in the listing agreement that plaintiff was responsible for the security of her own home. Obviously, we wanted it in. They thought the motion eliminated to keep it out. The judge decided, look, I don't think that the language is clear enough in there that a jury would be able to interpret whether or not that the plaintiff, whether or not she was responsible for the security of her own home. So the listing agreement did not come into evidence at trial. I do feel that the evidence at trial definitely supported the fact that she did not breach any duties and was not negligent. An overriding theme of here is that she has this duty to protect the home of plaintiff. There's nothing statutorily or otherwise that puts a specific duty on a realtor to protect one of their clients' homes. The jury instruction that was read to the jury explained what her duty was. It was to use reasonable care in representing her client and to disclose any material facts that she's aware of or should have been aware of. I would also argue that as far as material facts go, generally that goes to disclosure issues, whether there's water, any other issues with the home. But those were the duties as was read to the jury in the jury instruction. There was never anything in there that she has a duty to protect the home and the plaintiff. Only that she's used reasonable skill and care, and that she is to disclose any material facts. we would argue that the jury found appropriately, based on the evidence, that she did these things. When she met with the plaintiff, listed their home for sale, she told her on at least 2 occasions prior to the broker's open, make sure you put all your valuables away. She instructed them to do this. She assumed that they had done this. The evidence was they never told her about a safe. They never told her about how much jewelry they had or didn't have. So as far as Linda knew, she told them, you need to put all your valuables away.
But they did put their valuables away.
And arguably they did. Well, as far as she knew, I mean, and that arguably that was never really anything that came up because we never got to comparative negligence. But yeah, they had their items in a safe. So she did instruct them to do that. They never advised her, hey, we have a safe with items in it, please protect it. They never instructed her to do that. She wasn't even aware of it. All she knew is she tells all her clients, whether there's open houses or not, put your things away.
Well, if you get to the issue of, if you don't get to the issue of comparative negligence, if you're just talking about the duty, if the jewelry had been sitting out on a dresser, would we have a different analysis here? Let's say that the homeowners left out a valuable after they've been told to put them away.
No, because I think the job of the realtor is to use reasonable, she can advise them to put their valuables away. And then whether they do that or not, there's nothing.
That doesn't go to the duty though, does it? It goes to how much negligence there was.
On the part of the seller or the.
Yeah, so back up to just the duty.
Okay.
And let's assume for this that they have been told to put their valuables away and they don't do so, it's on the dresser. So we're removing all these issues about a safe and failing to lock the safe. And everybody's reasonable expectations of what might or might not occur. Is there a duty on the realtor if the jewelry that was sitting out in the open gets stolen?
No. I don't think it's any, well, I guess if she sees it, then maybe she would advise them, hey, you didn't put your things away, you need to put them away, I told you to put them away. I guess it would, and I will say in this instance too, she followed this man around. It's not like she didn't. She followed him up these stairs into these rooms as best as she could. She followed him back down again. She walked him around this house. So it's not like she left him alone.
But that seems, when you make that argument, it seems like you're saying she had a duty.
Well, she's showing him around the house. She had no idea this man was stealing anything. She's thinking, actually, they just thought this guy was, what happened is when he came in, the plaintiff was right there. He introduced, she said, oh, who are you? How did you know about, how did you get here? And he said, oh, my realtor sent me. The plaintiff was right there. She knew this was not a realtor. He introduced himself. He actually handed them a card of his alleged realtor, supposedly, that he was using. And they're thinking, oh, great, we've got a prospective buyer. She walked him around the house like she would anybody. She took him throughout the rooms like she would anyone. He came back downstairs. She came back. I mean, she wasn't thinking. It was never crossing her mind that this man was anybody other than a prospective buyer.
And he may not have been.
We don't know. I mean, arguably, he might, we have no idea who, but
let's back up to, because the argument is there is no comparative negligence in the contemplation of the jury because they found there was no duty.
well,
That's the argument.
well, no, my argument is that her duties were to use reasonable skill and care and disclose material facts, and that the jury found that she did that. I think
But there had been no breach of her duty.
They felt, yes, that she did not breach the duties to use reasonable skill and care, and she did not breach the duty that she did disclose all material facts. Our argument is we felt that the evidence supported those items, and so that they never even got to proximate cause or comparative negligence, because they felt that Linda Schubeck met her duties as a realtor based on the fact that she explained to them, put your valuables away, that She never told them they couldn't be at the open house, that they were allowed to be there the entire time if they wanted. She never told them they had to leave. They were aware that it was open to the public. She explained why, because an issue became as to, well, they thought it was a broker's open. They didn't think it was open to the public. She testified that she didn't see any difference as to whether it was open to the public or open to the brokers, that she advised them, put your valuables away. In her mind, that was appropriate regardless if the public is coming in or brokers are coming in. She put open house sign right in the front yard.
So she's saying, this is not a bailment situation. I'm not the guardian of everything that is within your house.
Correct. And there was a bailment claim, and that never got to the jury. The judge, actually, I think it was a combination of the plaintiff's counsel and the judge found that the evidence just did not support a bailment claim, because it was never one of these where I'm protecting your home, I'm here to protect everything in it, which is why the homeowners are allowed to be in the home if they want, which they were the majority of the time. She testified they were free to come and go, which they did. She never said, you cannot be here. They could have at any time went in the home, removed items, put in items, do whatever they wanted during this. She never told them they couldn't do any of these things. So it's our position that based on the testimony, it sufficiently met that the jury was able to clearly find that she used reasonable skill and care, and that she disclosed any material facts that she was aware of or should have been aware of, and that she did not breach her duties. And so I know that the argument is that he thinks that they thought the plaintiff was comparatively negligent, and so they misinterpreted that and find her not negligence, but I think the evidence was sufficient that, and all 8 jurors found her not negligent. It wasn't like a couple, there were no jury questions, it wasn't like they were confused. She testified, she testified she did not think she was negligent. She testified that, I gotta get into specifically what she had said. She said she did not feel anything she did was negligent, or that anything she did was the cause of plaintiff's damages. So her testimony was clearly, she thought she did not mislead the plaintiffs by using the term brokers open. She never told them they had to leave their house. She told them that they could stay. She never told them that she was going to be protecting or guarding their house. And so the evidence clearly was that she did her duty as a realtor and the duties as was charged to the jury. And again, there is no duty to protect the home. That's not how the jury was instructed.
Well, I thought the jury was instructed there was a duty.
They were not. The only instruction, and I put it in detail in my brief, that was the only instruction to them as to her duty. Statutorily, there's no duty as such. Unfortunately, the listing agreement did not come in because the listing agreement specifically states they're to protect their own home, but the judge kept it out. But yeah, no, the duty that was read to the jury was what I had put in my brief, the full instruction. That was the only instruction on her duty. And nowhere in there did it say the duty to protect the home. Just to use the reasonable skill and care and to disclose any material facts, in which we feel the evidence clearly showed. And the jury obviously felt the same, is that she did those items. Also, she testified she did not feel it was necessary to inform plaintiffs that no one would be looking out for the security of their homes, and she had told them on 2 prior occasions to take care of their personal possessions. She felt that because she had advised them to take care of their personal possessions, that, which was sufficient, and outside of that, again, they were allowed to be present during the open house. And so this wasn't something like she told them to leave, I'm the only one here. They were allowed to be there, and they were. So, again, we felt that the evidence, and as far as the manifest weight of the evidence argument, arguably the standard is to is that the presumption must be in the favor of the finder of fact. We think the jury did their job. They listened to the evidence, and they came to the correct conclusion that neither Linda Schubeck or Howard Gann were negligent in affirm trial court's decisions and denying the judgment, notwithstanding the verdict, and obviously ask you to deny the manifest weight of the evidence argument. So,
I was just going back to the charge. Use that duty to use best efforts to further the interests of the plaintiff, including but not limited to doing all the following.
right, and the only two that were applicable to this situation, because some of them have to do with whether you're you're representing a seller or a buyer, but the only two that were applicable to our situation were using reasonable skill and care. And then, while the disclosing of material facts may or may not have been, but those were the two, because we did go through with the judge all the different things that are listed in the revised code, and they just didn't apply to this situation. So the only two that did apply were the two that were read in the charge. But I will represent that the duty to protect the woman's home is not one of the other ones that are an option, so,
Thank you, counsel.
thank you.
I'd like to point out a few discrepancies, I believe, in the facts. Counsel just represented that the real estate agent went up and down with the unknown person who we believe stole this. That's not entirely true. She did not do that until my client came home and pointed out there's a stranger in her house. Who is this guy? Aren't you with him? And she admitted at trial that he was up, if you look on page 24 of the transcript, that he was able to enter her home and go upstairs for a couple of minutes. He was on his way down after being up there once when the real estate agent came around and made any effort as a result of my client coming home and saying what's going on here. To represent that my clients were there the whole time, I think is inaccurate also, or a substantial part of the time. That she came home to get something and left. I think the husband came home once too.
Counsel, with relationship to this gentleman's entering into the home, it's my understanding from the briefs that the homeowner alerted the agent, hey, someone just came in the front door. Is that correct?
Yes.
Okay.
And that's when she came out from where she was and went upstairs with him.
Is that statement made by the homeowner contemporaneous with the individual coming in? I'm trying to get a feel for does the record tell us the elapsed time?
He's already upstairs and she makes a statement and the real estate agent comes out and then they have this conversation and then they go back. But he's already been in the house and she would have never known had my client not come home. And to shift the burden on her because they accidentally did that, I think is unfair and inaccurate based on the record. I think that the charge is broader than counsel represents too. The judge clearly said that she had a fiduciary duty to use their best interest to further the interest of the plaintiffs. And to say that she told them they could stay in the house, the testimony is that they said, should we leave? And she said, most people do, and recommended it. She didn't say stay because nobody else is going to be watching your property or anything like that. I mean, if you can, I guess what they're saying here is they have no duty to disclose anything. They can misrepresent the status of who's coming to this open house, and if the people don't figure it out on their own because they put another sign in to make it click with that, then it's all on them. They draft the agreement here, and the court specifically found and interpreted that agreement against them that it had nothing to do with security. It only had to do with maintenance. And finally, the law is, and I think the closest case I cite to this situation is the federal steel case, where they say the general rule acceptance is where the original negligence of the defendant is followed by the independent act of a third person, which directly results in injurious consequences to the plaintiff. The defendant's earlier negligence may be found to be a proximate cause to the injurious consequences if, according to human experience and the natural ordinary course of events, the defendant could reasonably foresee that the intervening act was likely to happen. There can be no doubt here that the real estate agent knew that there's likely to be a theft here if she didn't do anything, because she advised them put your stuff away. And they did put their stuff away, and it's uncontradicted in the record at several places. In the deposition, she said, yes, they did a great job. On page, I think it's 164, she admits they complied. They did everything they were supposed to. Trusted this woman, lost $56,000 worth of jewelry because basically it was unconceded that they did absolutely nothing, didn't lift a finger to protect the contents of this home. And I think that should have given us at least negligence as a matter of law, and the case should have gone to the jury in the context of comparative negligence if there was a question of fact at all, which I submit there was not. Thank you.
Thank you both for your presentations this morning. The court will take a matter under advisement, issue a written decision, which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website. We are adjourned until next Tuesday at 7 o'clock. Thank you.